Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, Play the Opinion Potomac Watch Podcast. That is, Play the Opinion Potomac Watch Podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. I'm Paul Gigot with the Wall Street Journal with Alicia Finley and Kyle Peterson, talking about the ruling by Judge Terry Doughty that found the government had illegally pressured private social media companies to censor speech and violated the First Amendment, particularly on COVID. Alicia, there's no doubt here in the factual case, the discovery that the judge undertook, that these companies did censor speech. They did censor content considerably, correct?
Right. In many cases, it was they suppressed some of the content that they deemed quote unquote borderline, but that means that they prevented it essentially from going viral. People couldn't share it, so it had a very limited audience. Okay. And this was the Great Barrington Declaration, we know, was particularly contentious with Tony Fauci and government public health officials at the time. This is the declaration signed by many, many scientists, but Jay Bhattacharya and Martin Kulldorff were two of the promoters of this. And their argument was that you should take care of the most vulnerable people first and foremost, under COVID. Make sure that older people who had underlying conditions were protected, but let the rest of the economy stay open. That was not where Tony Fauci was. And they ran a campaign internally, which has been exposed later with emails against the Great Barrington proposal. Right. So in part of the ruling, they actually weren't able to find any instances in which the Tony Fauci and Collins actually pressured the social media companies. Okay. And so it was a lot of internal communications between the two saying that we need to basically push back against this in the media, like doing articles, Washington Post, providing quotes in those cases.
Which is not illegal.
This is not illegal. So I think that's actually one weak point in the judge's ruling, that just because they publicly denounced and tried to discredit the Great Barrington Declaration in the wider media, and then the social media companies kind of took the hint that, well, maybe we should also try to suppress this. I don't think that that passes as or meets the criteria as being coercive or significantly even encouraging, because there really weren't any direct communications, at least that they were able to uncover during legal discovery.
Okay. So it seems here, Kyle, that what we're talking about when it comes down to a legal matter is what qualifies as, how should we say, discussion between the government and these companies of the kind that we would have as journalists. Certainly I would have as an editor and have had with government officials who call and gripe about something or say, we sure would like you to write an editorial about this or that. You know, they don't say, Paul, we're going to pull your license. Well, there's no license to practice journalism, but we're not going to try to take away your job or something like that. They can't do that. Or we're going to sue you for something or other. But the social media platforms are vulnerable, as we said. But does it come down to, do you think, a fact-based question of just how coercive this pressure was?
How coercive it was, and also what the legal standard, the legal test for that coercion is, and whether it's different in the social media space than it is in other spaces. I mean, the difficulty of the analogies, I think you hit as a journalist. You can get calls from government officials that you maybe would describe as a frank exchange of views. And if you're a reporter doing something on the national security beat, I imagine, officials, White House officials may call you and say that this is very important national security information. If you publish this, you're going to expose sources.
And also say that you may end up being vulnerable yourself to some kind of investigation.
Well, or you may end up killing people because there are sources that are described in this that would be revealed. And to me, that sounds maybe persuasive or maybe not. But the question is whether the decision to publish still rests with the journalists and their editors. And I think that's the question here with social media as well, whether the decision to moderate that content or not moderate that content was still reasonably in the hands of Twitter, Facebook, Instagram, what have you, or whether there was so much pressure on them that they basically had no choice but to comply.
What do you think about that? Is that the line that you would draw here, whether this is actually a proper ruling or not?
Well, I think that the coercion is and whether it's implicit or explicit, I think that that's the key to the case. Now, I just want to use one other illustration is we've been seeing what's happened to Twitter since Elon Musk took it over and how Lina Khan has basically been harassing the company.
She's the head of the Federal Trade.
Basically because of his hands-off content moderation policies and has been subject to all kinds of document requests. And the FTC is also threatening to rewrite a privacy settlement with the company. And that just shows how vindictive the government can be. And the government really does have a lot of power over these companies. You know, it can't really pull licenses per se, but it can seek to put a company out of business, break it up, so to speak. You know, maybe the Biden administration would be doing these antitrust cases anyways, but some of it could also be out of sheer vindictiveness.
Does the judge cite any precedents for the linkage between government and private censorship?
Not actually censorship. He cites a lot of different case precedents to, as I mentioned before, the 1982, the Blum precedent, which involved a nursing home, and actually the basis in terms of whether or what qualifies as coercion and significant encouragement, which is the standard for to hold the government liable or responsible for violation of whether it be a First Amendment or other civil rights or other individual rights violation. But really in this realm of First Amendment rights, especially with regards to the media or social media, it really is an untested case.
There are not a lot of precedents here that have gone up to the Supreme Court. There is a case from some decades ago where the Supreme Court did rule on it was in West Virginia, I believe, where the government stood guilty of compelling speech because it amounted to a company town. It was just a small town where everybody more or less worked for the same company and therefore was deemed to be acting on behest of the government. But there's not a lot of case law on this. So this could set some new ground, Kyle. And I'm just reading between the lines of the Peterson coercion here or the discussion, and I think you're skeptical.
Well, at least I think that there is possibly a mixed ruling here where maybe some of the White House private statements to these social networks cross the line, and maybe the CDC apparatchiks coordination with Twitter on them asking, is there any truth to this claim, this health claim about a COVID vaccine, doesn't cross the line. But I think this is certainly one to watch just because it is, I think, setting some new ground and does raise questions for other areas of life. I mean, we were talking about a comparison to journalists earlier. What if you had a newspaper that ran an op-ed and the president says there is information in here that is libelous about me and my administration, and that's why I'm going to appoint judges that will overturn New York Times v. Sullivan, pass a constitutional amendment to change the libel standard under U.S. law. Is that a First Amendment breach? Is that a retaliation?
No, not at all.
I think there's a lot of cans of worms that are being opened here, and it's hard for me sitting here right now to see around all the corners about how they're going to be settled, but it is certainly going to be an interesting case, and maybe one or maybe we have to wait for another one to get up to the Supreme Court. There's another one that could be coming on Ron DeSantis and Disney, his removal of government benefits from Disney after Disney spoke out against the law concerning teaching of sexual orientation and gender identity in elementary schools. That is being litigated as a retaliation case, and maybe that will have some bearing on this as well.
Well, it strikes me as a very important area to be investigated and litigated because of the power of social media platforms to control speech. I mean, during COVID, we essentially had one part of the debate about COVID, which we carried on our pages. But that debate could not extend to social media because of the censorship of a lot of those views that the platforms undertook. You saw another illustration with the 2020 campaign with the censoring of the Hunter Biden story that the New York Post published about his laptop, which turned out to be entirely true. But because of the 51 former spies who said that at the time that was possibly Russian misinformation, the platforms used that as an excuse to censor. So there's a broad concern there for what this says about democratic debate. And it's bad enough if the platforms themselves, from all kicking in the same direction with the same point of view, censor alternative points of view. But it's much worse when the government is able to use them as agents of their official policy to censor dissenting or alternative points of view.
I think that's right. On the point about democratic debate, I would say two things, which is the person who is upset that Facebook keeps taking down their posts about how vaccines cause magnetism or alter their blood color is in the same position as the person whose op-eds on that subject keep getting refused by op-ed editors at newspapers around the country. And I think that it's easy to overestimate the influence of social media on democratic debate. Most Americans are not on Twitter. There is still an awful lot of speech that takes place off Twitter, and way more magnitudes, more speech than there was in the democratic debate even 10 or 20 or 30 years ago. And so there's a lot of speech out there, a lot of avenues for speech, and there are many companies that want to be the next Twitter. There is competition out there. One problem is the network effects. I mean, Twitter is powerful because everybody else is on Twitter, but also part of it is, I think, those moderation policies. There are unmoderated social media sites, and they tend not to be very pleasant places to spend a few minutes.
Alicia, you're going to get the last word here. What do you think about this issue and where it goes from here?
Well, I think that, as Kyle pointed out, there are a number of free speech cases headed up to the Supreme Court. Texas and Florida have tried to tackle this issue and passing laws that would restrict social media companies from censoring speech and speech of public officials and media companies. And the Supreme Court is now considering whether to grant cert to both of those cases and has asked for the Solicitor General's opinion. But I think those are probably the two more important cases to watch going up to the Supreme Court, and may decide also the extent of free speech rights for the platforms themselves.
Right, because those cases are about the governments of those states saying the tech platforms cannot censor, right?
Right. And the platforms in those cases are claiming that this is an abridgment of their First Amendment rights.
Right. To be able to decide what they want to say or not publish as content. All right. Kyle Peterson and Alicia Finley, thank you for this fascinating discussion. Thank you all for listening. We're here every day with Potomac Watch, and we will be back tomorrow with another edition. So hope you'll join us then.